The trial of the leader of the Tabligh sect in Uganda, Sheikh Yunus Kamoga, and 13 others for terrorism, murder and attempted murder started on the 17th October 2016. Several months later, Kamoga, 3 other clerics have now been sentenced to life imprisonment, while 2 of their co-accused will serve 30 years. Sheikh Kamoga and 5 others are accused of having committed terrorism verbally when they sent WhatsApp messages and convened meetings to plan for the death of Muslim clerics, but the court did not convict them for murder.
Though publication may include verbal expression, since it is not permanent, in my opinion, it should not amount to terrorism.
The judgment has attracted legal debate, with rights lawyers arguing that the conviction on verbal terrorism was an extreme measure.
For example, it's an offense to incite violence. It's an offense to incite tribalism. It is an offense. Some expressions, yes, but you see, in this case, it is so wide.
Ladislas Rwakafuzi, who is currently challenging sections of the Terrorism Act, says the conviction places an unreasonable limitation to the freedom of expression.
The problem is that slander is not an offense, but libel is an offense. Why? Slander is not an offense because it is temporary. You have said the words and they have gone. But libel, because it is in print.
In his 2004 Supreme Court ruling, the late Justice Mulenga had placed the bar for the limitation on the freedom of expression, saying that that which was demonstrably justified and acceptable in a free and democratic society, no matter how uncomfortable, was protected by the Constitution.
It's a very narrow and strict definition that you have to meet, because you have to justify why you're limiting free speech, because free speech must be allowed, even that which is most unpleasant. And in order to be able to limit free speech, there has to be really plausible nexus. In my own view, I think that in the case that the Ugandan court handled, there is absolutely no consensus if there is plausible nexus between utterances and possible violence.
The clerics now have 14 days to appeal the ruling of 3 High Court judges, which, if they do, will be an open can yet again on the freedom of expression debate. From now until they appeal, should they choose to, the Muslim clerics case has opened for the country a wide-ranging debate on what constitutes limitations to the freedoms of expression. Raymond Mujini, NTV.